I want to talk first about legal documents that someone who, whether they're doing Medicaid or estate planning, that they have to have. How many of you have a will? Okay. And how many of you have a trust? Okay. How many of you have a financial power of attorney? And how many of you have healthcare powers of attorney? So what we're going to do is talk a little bit about those documents and how important they are if you become sick or incapacitated, to provide that the documents, your assets will be distributed to the people that you want to, when you want them to, and in a manner that you want them to. And so it's not just a matter of having a will and at your death the assets go to the people you've named in your will. Some people call that death planning, because when you have a will, unlike what a lot of people think, a will only takes effect at the time of your death. And a will only provides for the transfer of your assets at your death. So anything that might happen to you during your lifetime will not be covered by the will. And in addition, when you have a will, one of the requirements is that you will have to go through probate. Now, probate isn't the worst thing that can happen to you, but some things it's close. Probate generally takes about a year from the time that you start, and you have to follow the certain requirements of the probate court in terms of filing petitions, preparing and submitting inventories, keeping track of all of the expenses and paying bills, and at the end distributing the assets. And so it's a process that's driven by the probate court, and the probate court sets deadlines that you have to comply with. And the biggest reason that people try to avoid probate is that they do not want to have to follow the probate court's timetable in terms of when things have to be done. And they want to have some flexibility and not have to wait a year before the assets can be distributed. When you have a trust also provides for the distribution of assets at your death. But in addition to that, it provides a way for managing assets during your lifetime. So that if you become sick or incapacitated, a trust will say that if I could become sick, that I want my assets to be managed by the persons you choose, and this is how I want my assets to be distributed during my lifetime. Unlike a will, the trust is effective during your lifetime. It doesn't just become effective at death. For people who want to avoid probate, and a trust avoids probate, people will often use a trust rather than a will. One of the purposes of documents is to have a trust or a will to distribute your assets at the time of your death, with the will not becoming effective until your death, and the trust becoming effective at the time that you sign the document. Another very important document is the power of attorney. The power of attorney is a document that you choose who you would like to be able to pay your bills and take care of any decisions that have to be made for you in the event you can't make them for yourself. Of all the documents, in many ways even more important than a will, is the power of attorney. Because if you have a bank account in your name and you become incapacitated and you can't sign because you don't have the legal competency to do so, there's no way for your bills to get paid. It's possible to have one person be your power of attorney for financial matters and one person be your agent for health matters. And what we say is that some people can be brilliant in terms of handling money and paying bills, but they've got a heart of a rock. They just can't make an emotional decision when it comes time to deal with mom or a basket case. They can't do it. Have a healthcare power of attorney. You would usually name a person to make the medical decisions for you, and then you name one or two backups. Now those people are authorized to make the medical decisions, but sometimes you need someone to help advise the person as to what their decisions really are, but you don't want to give them the authority to make the decision. And the best example that I have is when my father had cancer. He was having trouble fully understanding all this chemotherapy and the radiation and all that stuff. My mother at the time was in the middle stages of Alzheimer's, so she could understand stuff, but she really couldn't make any hard decisions. And so what Dad wanted is he wanted me to talk to his doctors and explain to me what they're doing and why they're doing and what his alternatives are, so that I can kind of translate it to English for him. And because I had a medical authorization, the doctors would talk to me. Had I not had a medical authorization, because my mom was the healthcare agent, they would not talk to me. And so, and even if you're a backup agent, they won't talk to you if you have a healthcare power of attorney. So most people, if they have children or have a family, will name all of the family members as agents for this medical authorization. It doesn't allow them to make any decision, but it allows them to talk to the doctors, and it allows them to look at the medical records. Those are the basic documents that all of us have to have. It doesn't matter how much money you have or how little money you have. Obviously, if you have a lot of money, then you have to worry about estate taxes. If you don't have as much, if you have less than $1 million, you don't have to worry about estate taxes. But whether or not you become incapacitated and can pay your own bills, it doesn't matter how much money you have. If you're not able to do it, if you have $1 million or $500, if the people can't get to the assets, they still have to go through the same probate procedure, and they still have to pay the same amount of money to go through that process. Estate planning is not dependent upon how much assets you have or how little assets. It's really, it's a sense of being responsible for yourself, so that in case something happens to you, that you have laid out things the way you want, rather than the way that someone else may want.